everyone, my name is Saffron Chisley-Farr and I am a part of the Chester Community Law Project. Recently, I have been researching flexible working rights for families and employees. Today I will be talking you through the flexible working rights for employees, and I hope that you find this useful. So, what is flexible working? Flexible working allows employees to alter their working pattern. This can include how many hours they work in a week, when they start and finish their shifts, and as well as where they actually complete their work. The arrangement can also be set for a certain amount of time. Although this is more common to be used by parents and carers, all employees have the right to apply for flexible work. As you can see, on this slide are numerous options as to why an employee may request flexible work. These include flexi time, compressed hours, remote work, job share, and as well as zero-hour contracts for part-time employees. Flexi time, simply put, is when an employee will still work a set number of hours in a week or even a month. However, their starting and finishing times for their shifts may alter for certain days. They are chosen and agreed limits are set by the employee. For instance, they may alter their contract to a 35-hour week with flexi time. Compressed hours are similar to flexi time, as the hours are still contracted for the week, although rather than requesting to alter your starting and finishing times, the employee can complete the hours of work within a fewer number of days. So rather than working a 35-hour week Monday to Saturday, the employee could work a 35 hours Monday to Thursday, having longer shifts but with more days off. When it comes to remote work, this is especially relevant to the COVID pandemic we are currently in. Some work can be completed via Zoom calls or emails, whereas before the pandemic, meeting clients and lawyers, for example, would have been face-to-face and in person. However, having remote workspace such as working from home has provided many benefits to the employee, such as being able to care for their children, which results in free childcare. It has also been suggested that remote working has resulted in an increase of productivity, which is a huge benefit to employers, in addition to the company increasing their savings on new equipment. Moving on to job shares, this is mainly used between part-time employees, where usually two part-time employees share the responsibility for the job between them. They share the task and have the pay of a single full-time job. Again, even though this may appear time-consuming or a waste of an employee, there are many advantages to job shares. For instance, there is twice the amount of enthusiasm, creativity and dedication given to the task. It also gives the employees the opportunity to balance work life alongside home life. Whereas if they were working by themselves, it could lead to them having to quit in order to find the balance between work and home life elsewhere. Finally, annual hours. Here, the total number of hours to be worked over the year is fixed, but there is variation over the year to the length of the working day and week. With this aspect, it is possible that employees may or may not have an element of choice over their working patterns. One of the main advantages to working annualized hours is that they can provide more security for employees. This approach can also aim to give employees longer periods of holiday while still enjoying a guaranteed monthly salary. Consequently, it is clear to see how each of these flexible working methods, when done properly, can be very effective for the employer and their business, as well as to the employee. As mentioned briefly on the previous slide, there are many different ways in which flexible working requests can be applied, whether it is for certain shifts or days of the week, or even for specific weeks throughout the year. However, it is crucial to understand that once the application has been accepted, that the specific change is permanent to the employee's contract, meaning that another application or request would have to be filed in order to change the contract back or add further changes. And from this point, the request can still be denied, as there are still, of course, regulations attached to the application. When applying for flexible working, the employee must have continuously worked for the same employer for the last 26 weeks. There are some basic formal steps of action, starting with the employee writing to their employer about the matter. From this, the employer can then consider the request and report a decision within 3 months. This can be extended if agreed with the employee. If the employer agrees to the request, then the terms and conditions of the employee's contract can be altered. However, if the employer disagrees, then they must write to the employee giving the business reasons for the refusal. In this case, the employee is able to complain to the employment tribunal. There is more detail on this process on the following slide. Here you can see exactly what is to be included in the employee's letter to their employer for the flexible working request. Items such as date the letter was written, what the specific request entails, and additions such as when it would be preferred the changes to the contract would start and how long for. As already mentioned, the request for flexible work or a change in the employee's contract has to be made in writing. Although there is usually no issue in accepting the request for flexible work, if the application is rejected, the employer has a legal obligation to the employee to explain the reasoning for refusing the request. Most of these reasons are based on how the change would affect the business as a whole, such as the team of employees around the individual and the impact to service to the customers, or it could be down to financial resources which may be limited to the company. Carrying on from denied requests for flexible work, if the employee is not satisfied with the reasoning from their employer, they also have a right to take the matter to the employment tribunal. In doing this, the employee must follow the company's procedures for appealing to the employment tribunal. Moreover, the employee or the employer should also follow the company's procedures for solving workplace disputes. If said rejection of flexible work causes problems, however, taking the matter to the employment tribunal cannot be just because the flexible working request was rejected. There has to be sufficient reason. These can include if the application was not handled in a professional manner, if the request had been wrongly denied, or if the rejection occurred based on incorrect facts. Finally, if an employee does make a claim to the employment tribunal, in this event, there are numerous ways in which the tribunal can act. They can make a declaration of the employee's rights. They can also make the employers reconsider the original request, as well as award compensation to the employee. It should also be made aware that it can be possible to claim for discrimination or unfair dismissal, but employees should raise their problems with their employer before taking the matter to the employment tribunal. I hope that you have enjoyed this presentation on flexible working. There are also many more presentations available which you may find interesting, especially if you have found this one helpful.